Welcome back. So let's look at an interesting topic which affects you and I, and it's called labor and employment. Why I said it affects you and I is because it's either you're playing as an employer of labor or you're an employee delivering services to an employer of labor. So one way or the other, you are being affected. Even if you may consider yourself not to be an employer nor an employee, one way or the other, you are caught in the middle of both parties. So it affects you directly or indirectly. You see, for starters, labor and employment law is a broad subject that deals chiefly with employer and employee relationships, unions, and other stakeholders. If you are a trader, for instance, entrepreneur, or a consultant, you might find something of interest under this topic. You see, as a legally recognized employee of a company, you have certain rights and laws in place to ensure your safety and fair treatment when working for companies operating in, for instance, Nigeria or whatever jurisdiction that you are in. You have probably come across them in your employee handbook, which I know most of us do not read, or even if we read, we just gloss through and not read to the end. Or at some point, you must have signed a statement indicating you have received a copy of them and have read them. The next paragraphs or slides we're coming into may come as a shock to you. So fasten your seatbelts and let's enjoy the ride and see what it holds in stock for us. First, the Nigerian Labour Act, which is the primary legislation that regulates the relationship between employers and employees, is not applicable to all classes of employees in Nigeria. Is that a shocker? Wait for the next one. The Act uses the word workers in describing employees and went on to define workers as not including persons exercising administrative, executive, technical, or professional functions as public officers or otherwise. This suggests that if the nature of your role is administrative or executive or technical or professional, you might not be covered by the Act. Anyway, the Labour Act only covers employees engaged under a contract of manual labor or clerical work in private and public sector. You see, under Section 91 of the Labour Act, a worker is defined for the purposes of the Labour Act as any person who has entered into or works under a contract with an employer, whether the contract is for manual labor or clerical work, or is expressed or implied or oral or written, and whether it's a contract of service or a contract personally to execute any work or labor. You see, it is pertinent to note the exclusion of persons exercising administrative, executive, technical, or professional functions as public officers or otherwise from the ambit of the Labour Act. What does that leave us with? You may be wondering, what does that leave us with? So what happens to the excluded category, which I assume most professionals fall under? Terms of employment of such excluded categories of employees are governed by the terms and conditions contained in their respective individual contracts of employment. This brings us back to the contracts, as the principle governing general contract agreements will also apply to contracts of employment. Therefore, we'll look closely at some of the things, a few highlights of the Nigerian labor law and allied matters connected therein. First is the concept of forced labor. Do know that it is illegal to force anyone to work against their will. it is every Nigerian's right to be free from forced labor. And this right is guaranteed under the 1999 Constitution. Apart from existing in the Constitution, it is also restated in the Labor Act. Therefore, if you are being forced to work against your will, you can report to the police as it is a crime. However, the Labor Act gives the government the ability to requisition people to work during an emergency or a calamity, and this will not be classified as forced labor. Another thing that may interest you under our Labor Act is written contracts. You see, despite recognizing the various ways of establishing an employment contract, Section 7 of the Labor Act still asserts that an employer must give an employee a written contract within 3 months of the commencement of the employment. So if after 3 months of commencement of your employment and there is no written contract, you may wish to exercise your rights. I wouldn't tell you what those rights are. And it says something again that is of interest. Now, the contract must have certain key terms, which include, but not limited to, name of employer and employee, nature of employment, the duration, the wages, etc. You see, the essence is to ensure that the employee is protected by all relevant terms being reduced into writing, so the employees are abreast of his rights and duties, and as well as his job descriptions, what are expected of them. Also, important is that if there is any change in the terms of employment, it should be made known in writing to the employee within 1 month. So you cannot just wake up and alter the terms of employment without giving notice. Let's talk about something else, wages. Any contract where the whole or part of the worker's wage is made payable in any other manner apart from the legal tender shall be illegal, null and void. So that means the legal tender is the only acceptable means of payment of wages. Therefore, it is illegal for your employer to attempt to pay you with things other than money. If your other key things to note around wages are, it is illegal for any contract to be for payment of wages at intervals exceeding 1 month. Yes, you should bear that in mind. Unless the written consent of the state authority is sought and received. This means if your employer makes you sign an employment contract where the employee is to be paid every quarter or every 6 weeks, etc., such a contract is illegal. See, no employer can impose any restriction as to the place and manner in which the employee can spend his or her wages. So, your employer can't insist that you only buy lunch, for instance, from the office canteen. Nobody can regulate how you spend your wages. Employers are not allowed to provide an advance wage in excess of 1 month. Let's look at salary deductions, for instance. Employers are not allowed to deduct an employee's wage for any reason, unless reasonable deduction for injury loss, costs to the employer by the employee, but only with prior written consent of an authorized labor officer. Yes, sought and received. Also, if mistakenly you are overpaid, then you should know that the money which was overpaid can only be deducted within 3 months from the date of the overpayment. Any attempt by your employer to deduct the overpayment from your future salary after the expiration of this 3-month period is illegal. Interesting times. Now let's look at trade union membership. No employment contract can prevent workers from joining trade unions. Yes. And any contract which makes it a condition of employment that the worker should relinquish membership of a trade union or prejudices workers by reason of trade union membership is illegal. So, let's look at best hours, sick leave, and holidays. If a worker is at work for more than 6 hours a day, he or she must be given at least 1 hour of rest interval in the day, in that particular day. Further, in every period of 7 days, a worker is entitled to at least 1 day of rest, which must not be less than 24 consecutive hours. Every worker is also entitled to 12 days sick leave for temporary illness certified by a registered medical practitioner. In addition, every employee after 12 months of continuous service is entitled to a holiday with full pay of at least 6 working days. This is exclusive of all public holidays. Interesting times. Now, let's talk about maternity leave. Maternity and paternity leave. Just like what's obtainable in the West, all female employees are entitled to at least 12 weeks maternity leave with full pay. Unfortunately, the Nigerian Labour Act does not recognize paternity leave, just like the Western counterparts do. And paternity leave does not exist here, and it makes no such provision. However, in Lagos State, for instance, civil servants are entitled to 10 days paternity leave within the first 2 months of the birth of the baby. So though the Nigerian Labour Act does not, the Lagos State's legislations and laws do recognize that. Transfer of employment, for instance. An employee must consent to the transfer of his or her employment from one employer to another for it to be valid, and the transfer must be endorsed by an authorized labor officer. So if, for instance, your company is taken over by another company, your employment will not be automatically moved to this new company without first getting your consent and getting you to agree to that transfer of employment. Your consent must be sought, and not only sought, it must be received clearly and unequivocally. Termination of employment. With respect to the termination of an employment contract, the Labour Act provides for minimum notice periods as follows. Where the employee has been employed for a period of 3 months or less, either party may terminate the contract. Yes, either party may terminate the contract. And how can they terminate the contract? With a minimum of 1 day notice. Where the employee has been employed for a period of 3 months but less than 2 years, either party may terminate the contract with a minimum of 1 week notice. Where the employee has been employed for a period of 2 years but less than 5 years, either party may terminate the contract with a minimum of 2 weeks notice. Where the employee has been employed for a period of 5 years or more, either party may terminate the contract with a minimum of 1 month notice. When giving notice of termination of employment contracts, where the notice is 1 week or more, the notice must be in writing. So, bear that in mind. And as you do, it may interest you to know that the laws keep evolving. But notice that what we've said here applies to Nigeria. In the western part of the world, there are little variants here and there, just like in other parts, in other jurisdictions. There are little variances here and there. So this is not an all sides fits all kind of rule. This is applicable as it is in Nigeria. So Nigeria is our case study in this situation. So if, for instance, you are working in North America or you're working in Europe, you have to familiarize yourself with the employment laws of those of that jurisdiction, to be able to know what's expected of you, to know what your rights are, to know what your duties are. However, should you have issues regarding employment, in terms of should you have things that you feel you're entitled to and they are being denied you, these are issues you bring to an labor lawyer or an employment a labor lawyer typically handles. This is the sphere where a labor lawyer handles and can be able to put you through and guide you and advise you on how best to approach issues like this. So with that, we come to the end of labor and employment law. Like we keep on emphasizing, this is not exhaustive. There's so much to discuss under labor and employment law. However, this has been designed to let you know the basics and some of the things that has been put in place, and let you know that there are laws put in place to protect your rights as an employee, and interestingly, though I didn't emphasize it, as an employer as well. Should you have questions regarding this, do not hesitate to send me an email, and I'll be more than delighted and glad to reply you and provide you answers to some of the questions you have to the best of my ability. Till then, thank you for choosing Techidia Media Institute, and see you at the next slide. Bye.